Okay guys, welcome back to the channel. It's good to have you all here and I hope that you're all keeping well. It's me again, Cal, your personal pocket-sized lawyer, and today I'm teaching you some inside legal tips from the legal profession, specifically how to get out of any contract early. This is not one you're going to miss, and let's get straight into it. So look, the purposes of this channel is to teach people what life won't ordinarily teach them, what schools won't teach you, what your peers won't teach you, because while you spend your early years learning about rock formations in geography class, no one is teaching people about basic everyday legal challenges like how to get out of unfair contracts, finance contracts, car leases, gym memberships, dodgy training courses. Look, 4 out of 5 people in the UK have signed a contract that they didn't fully understand or later regretted. Many contracts are designed and are created by greedy businesses to trap you and keep you trapped. So let's put some power back in your corner then. This is how this video is going to go. We'll go through firstly the standard legal exits. Yes, you have to try these first. And then I'll show you the less obvious tricks, legal pressure tactics, some inside loopholes that as a lawyer you pick up on the way. And the best bit is I'll do it in all under just 9 minutes. So let's get straight into it. Look, the truth is just because you signed something, it does not mean that you are completely trapped. Contracts have legal requirements to them. And if those aren't met, or if circumstances change, you may be able to walk away from that contract legally. Okay, so let's start with the more obvious but still way overlooked ways to cancel a contract once you're in it. Number 1, the cooling off period. Right, so if you signed the contract online or over the phone, you might have an automatic right to cancel that contract within 14 days under the consumer contracts regulations. This applies to things like gym memberships, phone plans, private lessons in which you arranged over the phone or online. Those are the typical types of contract. Now, the key is when and how you sign the contract. Always ask yourself, was this signed face-to-face, online, or at a distance? If it wasn't in person at their business premises, then you may have a cancellation window called the cooling off period. So have a look, see if you can see one in your contract. A quick one before we continue, guys. I'll never ever ask you at any point to hit my subscribe button, only that you give me the opportunity to earn it with the content that I have made for you. So if at any point in this video that you feel like you'd like to learn anything or take anything of value from it, then please feel free to do so. Now, for number 2, you want to look for or ask yourself, has there been any breach of contract here? Even a slight one. You might think this means waiting for the company to completely mess up, but no, even tiny breaches can count. For example, let's say you've got a broadband contract, guys, you want to get out of, or a phone contract. Let's say the contract states that you're guaranteed 50 megabytes per second in broadband speed, but sometimes you're getting below that. Or in phone coverage cases, you're not getting phone coverage where they promised that you would get it. These are material breaches that can free you from your contract, and you can weaponize them if you need to get out of that contract in the future. So whenever you suspect a breach, note it down and keep evidence of it, guys. Always do that whenever you suspect a breach. It can be your way, your weapon to get out of a contract when you need to. What you should never ever do though, guys, is waive those breaches. You don't actively tell them that you forgive them for that breach unless you absolutely have to, because again, you may need to rely on it to get out of that contract later. Now, the third way to exit your contract is through unfair terms. Under Consumer Rights Act 2015, any unfair term in any consumer contract can be challenged and then often struck out. That means hidden cancellation fees, rolling renewals without notice, one-sided clauses where they can cancel but you can't. You might think just because you see a clause in a contract that it's fair and it's legal. No, as a lawyer, I'm telling you, not all clauses are enforceable. Under the Consumer Rights Act 2015, unfair contract terms aren't binding, but companies will very rarely ever admit this to you. Now, this strategy works best with things like subscription services and financial contracts and letting agreements. And another common example is early termination fees, guys, written in small print and not clearly explained. So here's your action, guys. Here is your action point. Look for terms that seem excessive in terms of fees and small prints and vague and ambiguous language. And finally, one-sided terms. Look for one-sided terms that favor them over you. Challenge them over it. Quote the Consumer Rights Act 2015, and that should see you out of your obligation. Now, the fourth way I really love is what lawyers call frustration. And this is a very cunning tactic. Now, a contract is frustrated when something drastically changes. Now, this is a legal concept, guys. It says a contract can be cancelled if something happens that makes it practically impossible or radically difficult to fulfill. For example, if an unforeseen event makes it impossible to perform. COVID lockdowns made this one famous, didn't it, guys, when a pandemic meant that people couldn't leave home to do their jobs. But it also applies to things like losing your job, meaning that you can no longer afford your lease. Illness, making you unable to attend like that PT program that you signed up for, or relocation, as a result of a family emergency. Companies don't like it, but guys, the law is on your side there. Even if you're not sure, just argue it anyway. Claim that a specific event has frustrated your contract by law. Many companies will try to avoid that legal fine whatsoever. Now, into section 3, let's talk about loopholes and tricks that people don't want you to know, okay? So let's say you've tried the above standard exits and you can't get out of the contract in the more conventional ways. Now it's time to start getting a bit clever. So number 1, look for execution errors. Look closely at how the contract was signed. Some contracts are invalid simply because they weren't properly executed. Was it missing a signature? Was it signed by someone who didn't have the legal authority to sign it? Was it supposed to be witnessed when it was signed? It wasn't. If it wasn't properly executed, guys, it may not be valid at all. This often applies to things like property contracts that require a wet ink signature or loan agreements and things like that. Now, the second trick you can do is to use their own policies against them. Now, many companies have discretionary hardship or exit policies, but they don't advertise them. You've got to ask about them. Be polite, provide your evidence of your hardship, and remind them that treating vulnerable customers unfairly can land them in hot water. And that leads us to number 3, for the more cunning amongst you. If you are really, really struggling to get out of your contract and you really need out, you need to look for leverage. Now, this is underrated but powerful. So if a person or company you've signed a contract with has broken the law or a regulation that you somehow know about, even something unrelated to your contract, you can use it as leverage. Perhaps they've breached GDPR rules with your personal data, or they've spammed you illegally, harassed you, told you a secret about one of their clients. You might think this is unfair, but this happens all the time in everyday contracts and agreements. The world isn't always a fair place. But if someone is outright refusing to release you from your contract, you can use their illegalities as leverage to release you from your own obligations. I've done it before and it works wonders. If after all this you're still stuck, but you genuinely believe that they are unfairly keeping you in contract, then it's probably time to escalate. What you need to do is mention the ombudsman relevant to the industry, so the financial ombudsman or the legal ombudsman, and that you will raise the issue to them. They are the body that judge trade fairness. You can threaten to leave a horrible Trustpilot review. You can mention contacting trading standards companies. A lot of companies will crumble as soon as they sense that you're going to cause reputational damage. They'd often rather release you from your deal than deal with bad PR. This works well with freelancer contracts, guys, courses provided by freelancers where reviews and reputation are essential to them. But guys, let me know your thoughts. I really want to hear from you on this subject, what your experiences with contracts that you've been unable to get out of, what has worked for you, what did not work. Let's help each other get a discussion going down in the comments. And guys, finally, remember, this is not qualified legal advice for you to rely on alone. It's purely educational content. I cannot provide qualified legal advice on YouTube. That said, I'll see you in the next video.